Hello and welcome to today's webinar. My name is Paula Price. I'm with the People's Law School, and today we are talking about personal injury law in BC, your everyday questions answered. And we have an excellent presenter, Jackie Small, and I will introduce her in just a few minutes. Of course, today we are talking about personal injury law in BC. Topics we'll cover include common injuries and the laws that apply, what to do if you get injured, how to bring a claim, and finally, protecting yourself against claims. What you will receive today, we are going to be sharing answers to common questions. It is legal information, not advice. So if what you're looking for is the law as it applies to your unique set of circumstances, then we encourage you to reach out to a lawyer. You're welcome to reach out to our speaker today, Jackie Small. Her email address is on the screen, jsmall@wholenessandsmall.com. And of course, the information that we're sharing is current as of today, June 23rd, 2026. We would like to acknowledge that we, the People's Law School team, are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we encourage everybody to reflect on where it is that you are joining us from as well. We would like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support makes it possible for us to provide these webinars. And last but not least, we would like to thank and welcome our panelist, Jackie Small. Jackie Small is a lawyer and partner at Holness and Small Law Group in Vancouver. Over the past 16 plus years, Jackie has dedicated her career to representing the injured. Her practice covers all types of personal injury claims, including occupier's liability. So that's where you're injured on a premises. That includes slips and falls, medical malpractice, sporting and recreation, and ICBC claims. Jackie has a deep understanding of personal injury law, both from the perspective of the person who is injured and the insurer that is often on the other side of claims. We're thrilled to have Jackie here today to share her knowledge and expertise. She has a gift for explaining the law in a way that is clear, empathetic, and actionable. Welcome, Jackie.
Thank you very much for having me.
Oh, thank you so much for coming. And with that, we're going to start out with our questions. And the first question, Jackie, is, what are examples of personal injury claims people make in BC other than motor vehicle injury claims involving ICBC?
Well, there are several, and you've touched on a few already. So I'll start off with medical malpractice claims, and these claims relate to injuries that are suffered as a result of an error or errors made while receiving medical treatment by a healthcare professional. Some examples include misdiagnosis, surgical errors, prescription of incorrect medication, lack of consent to medical procedures. And this type of claim can potentially be made against a variety of different types of healthcare providers, such as doctors, specialists, hospitals, nurses, medical clinics, and they can also be advanced against non-doctor medical practitioners, such as physiotherapists and chiropractors, for example. The next type of claim is occupier's liability. And occupier's liability claims relate to injuries that are suffered on someone else's property, either private or public, because of a hazard or an unsafe condition. The right to sue or bring a claim against an occupier is governed by written law, which is known as the Occupier's Liability Act. And generally what that act says is that as an owner or occupier of a property, you are responsible for ensuring and keeping the property safe. Some examples of hazardous conditions would be poorly lit areas, defective railings, unsafe stairways, holes that are obscured, parking lots that are icy, poorly maintained sidewalks. And the claim for compensation can be made against private landowners or tenants as well as public landowners such as the province or a municipality. Next kind of type of claim is a WorkSafeBC claim, and those claims relate to injuries that are suffered at work. And this law is also governed by written law as well. And it states that if you are working and you're in the course of your work while an injury happens, you are restricted to bringing the claim through WorkSafeBC for compensation. The law does not allow you to sue your employer or a coworker that may have been responsible for the injury. It is considered also a no-fault type of claim where you don't have to prove who was at fault, just that the injury occurred in the course of work. Examples of potential claims could be long-term exposure to hazards at the workplace, mental health disorders caused by traumatic incidents at work, and general accidents, slipping and falling off a ladder, anything in the course of employment. And while we have a number of other types of personal injury claims, I will address one more, and that's civil sexual assault claims that are suffered, where injuries are suffered as a result of sexual violence, abuse, or misconduct. Claims can be made against the abuser, that may be an individual, family member, or an institution, such as a church, co-workers or spouses. Yes.
Excellent. Thank you so much, Jackie. And I think what you've highlighted here is that there really is a breadth of different types of claims. And as you've pointed out, there's a different legal regime potentially that will govern each of these. And so we're really delighted to have you here today to help us understand what those laws are and what that means for people who have suffered injuries. So you mentioned icy driveways and occupiers' liability. So those might ring true here, right? While visiting a friend at her home last winter, I slipped and fell on ice in her driveway. I broke my hip, resulting in a painful surgery and 2 months off from work to recover. I don't want to sue my friend, but I also want fair compensation if I'm entitled to it. How does the law work? Will my friend be on the hook, or will her insurance cover it?
All right. So just as you said, this is a claim likely in occupier's liability. So if your friend owned the home at the time, then she would have been legally required to take reasonable steps to ensure the driveway was safe by clearing ice, warning visitors of a potential hazard, or salting. And if she failed to do that in terms of making the driveway safe, by not shoveling or salting or doing it often enough, then she would likely be found liable for the injuries as long as that hazard caused the fall and the injury. If your friend had homeowner's insurance at the time of the accident, then she would very likely have protection through the insurance if someone was injured and advanced a claim. In that circumstance, the insurance company, not the friend, would then likely pay all costs associated with the claim. And that would include the compensation payable, as well as any legal and court costs. The problem really arises if your friend did not have any homeowner's insurance, or if she was a tenant, any tenant insurance. And if that's the case, then she would very potentially be found personally responsible for all of those costs, because there would be no insurance to otherwise cover it. Depending on the extent of the injury, those costs could be substantial, and then potentially in the tens of thousands of dollars or hundreds of thousands of dollars, or even seven figures. It really depends on the seriousness of the injury.
Excellent. Thank you so much, Jackie. Um, this next question is one that I think a lot of parents of young children will relate to. My son is 9 years old. I have to sign a waiver almost everywhere I take him, including the local trampoline park, the theme park, and the ski hill. I sign the papers put in front of me, but I worry about the risk. What if my son actually gets injured? Have we lost all rights to make a claim?
Well, this is an excellent question. Now, just to explain what a waiver is, it's essentially a contract between the participant in the activity and the operator who's putting on the activity. And in signing the waiver, what it's asking you to do as an adult would be to waive any legal right to make a claim for compensation if an injury is suffered while participating in the activity. In essence, if you sign a waiver, then you're accepting the risk and potential injury in participating. Waivers generally are enforceable if they're signed by adults. The waiver has to be properly drafted. It has to include detailed information about the risks and hazards involved in the activity. And very, very importantly, the adult needs to be provided with an opportunity to review the waiver before it's signed and dated. And the injury must have been suffered while participating in the specific activity. So just to use an example there, if you go on a ski hill and you sign a waiver and the injury is suffered while skiing, then the waiver will very likely be enforceable, no matter how serious the injury is. However, if the injury occurred in the parking lot while unloading the car and the hood of the car came and hit someone on the head, then that waiver obviously would not be enforceable because it's not in relation to the activity. Now, if the waiver is enforceable, it's a complete defense to the claim. There is no way around it, and it's in very exceptional circumstances that the waiver would not be enforceable. Thankfully, in British Columbia specifically, the situation is very different for parents that sign waivers on behalf of their children, in that waivers are not enforceable when they're signed by a parent because of written law in this province, which is the BC Infants Act. And the BC Infants Act does not permit a parent or a guardian to bind an infant to the waiver that waives the infant's right to bring an action. Now, I've been using the term infant. When people hear infant, they think very small child or a baby. The law in Canada is that anyone under the age of 19 is considered an infant.
Interesting. Wow. Okay. Well, thank you so much, Jackie. That's really helpful and informative. Here we have another question. I recently had knee surgery. My knee feels worse now than it did before, and I can barely walk. Do I have a viable claim against the surgeon who did the procedure? What steps do I take to find out?
So this sounds like a potential medical malpractice claim. And again, medical malpractice claims refer to injuries suffered as a result of medical errors that are made by healthcare providers. A very important consideration when determining if a healthcare provider or the surgeon in this case is at fault is whether the treatment fell below what's called the standard of care, and that caused the injury. So what the standard of care is, it's the level that a doctor is expected to provide medical care at, and how it's measured is against what an ordinary prudent doctor with similar skill and knowledge in the same circumstances would have done. Proving medical malpractice claims is inherently very, very difficult to prove. And that's because healthcare providers are given latitude in the law to use their clinical judgment when choosing which option to proceed with, even if they choose the wrong one. So if we look at this scenario with the surgery, if it can be proven that the surgeon performed the surgery against the usual policy and procedure, and that another surgeon in similar circumstances would not have proceeded in that way, and that there could be maybe warnings about a lot of risks associated with proceeding that way and recommendations to proceed another way, then it could be that the surgeon may be found at fault as long as the worsening of the knee is a direct result of the type of surgery that knee surgeon decided to proceed with. Now, how do you find out if you have a viable medical malpractice claim? Because these claims are so difficult to prove, they are very, very complex. It's highly advisable to contact a personal injury lawyer to find out your rights. And I always recommend that you choose a personal injury lawyer that has medical malpractice experience because it is such a specialized area of law, that those lawyers with experience will know the nuances that perhaps another personal injury lawyer that doesn't have experience would know. And that may be crucial to the success of the claim. Now, if we look at the example that we just discussed with the knee surgery, a few things to find out right away and to understand. The first one that I would say is the limitation date. Now, the law in this province states that with medical malpractice claims, you must commence legal proceedings within 2 years to the date of taking this example, the surgery, or the date that it became known that something went wrong with the surgery. The limitation date is not flexible and it cannot be extended except in very extraordinary circumstances. So, with this, it's very important that you seek legal advice before that limitation period expires. If no legal action is taken within that 2-year time frame, then you will never have a right to bring that claim again. It essentially ends definitively. What I would recommend you do in terms of getting prepared to meet with a medical malpractice lawyer is to compile a timeline of events, including the dates that your knee started to become an issue, and starting from the first medical advice that you sought leading up to the surgeon, the date of the surgery. Make a list, if you can, of all the doctors involved in the care, starting with the family doctor to the knee surgeon, as well as any clinics and hospitals you attended in relation to the surgery, as well as care afterwards. I would also recommend that you request a copy of your medical records. So if we're looking at the surgeon example as well, you would definitely want to request your records from the hospital. You're entitled to those records. And those are very important for any potential lawyer to review because it will provide very, very insightful information. But again, with medical malpractice claims in particular, it's highly advisable to seek some advice before any real steps are taken because they are so complex and difficult to prove.
Excellent. Thank you so much, Jackie. Um, Really excellent, thorough answer to the question. This next question, I recently injured my elbow playing baseball. My doctor recommended lifting weights. I started lifting weights, and now my elbow is worse than before. I need surgery to fix it. Do I have a claim against my doctor?
So this again is a potential medical malpractice claim, and similar to the previous knee surgery fact scenario that we were discussing, you must prove that the doctor breached the standard of care expected of him or her in the circumstances in recommending lifting weights, knowing the extent or type of injury suffered. So in order to determine whether the doctor was at fault for recommending that, again, what would be analyzed is whether a doctor in similar circumstances would have recommended lifting weights, or if that was one of the many options that could be recommended. Where things go wrong and where there's potential liability is where perhaps it's well known within medicine that recommending lifting weights with this type of injury runs a very high risk of making the injury worse or aggravating the injury. Whether there were any warnings that were known in medicine against doing this, and perhaps whether there was a way that the doctor could have examined the injury to determine whether it was whether the elbow was healthy enough to start lifting weights and if that examination never took place. So if it can be proven, again, that the doctor in recommending lifting weights was breached the standard of care, that other doctors would not have recommended that because of the known risks, you must also prove that it was the lifting of the weights that caused the worsening of the injury, not some other factor. And where it may become a bit murky is whether that elbow was very susceptible to being aggravated, whether or not you lifted weights. That would be a very important consideration. So making that connection between how the injury happened is essential. It has to be as a result of the medical error, and that's known as causation. So you must prove that that act caused the injury and it wasn't caused by something else in order for the claim to be potentially valid and worth pursuing.
Excellent. Thank you so much, Jackie. Um, and Jackie, this next question is a question about. I'll read the question. I finally worked up the courage to end my marriage of 10 years. My partner was controlling, emotionally abusive, and sometimes physically abusive. I was so scared. I rarely talked to anybody about it, and I never went to the police. Could I have a claim for damages against my ex?
Well, this is an excellent question. And if you had asked me this a number of months ago, I would have said there's very likely no claim that can be made. But we're extremely fortunate in Canada that the Supreme Court of Canada very recently created a new type of personal injury claim called intimate partner violence. The Supreme Court of Canada is the highest court in Canada, so when they create a law, it is applicable across Canada. And this is a very important step that's been taken because traditionally, this type of abuse was never considered compensable, regardless of the extent of the harm that it caused to the person, the victim, and the survivor. So, intimate partner violence would include anything from physical violence to isolation, humiliation, financial control, sexual coercion, and intimidation. And it only applies between romantic partners, whether you are married, whether you're in a common law relationship, or whether you're in another form of committed relationship. And there are three things that must be proven. Now, this is a brand new law, and it has not been tested. So I think there's going to be likely parts of this law that will be changed and defined a little bit further as cases start to come through here. But as it stands right now, the Supreme Court of Canada stated that the three things to prove in order to have a claim for compensation would be first, that the abuse took place in this intimate spousal partnership. And just to clarify, it would not apply to other family or friend relationships, such as between parent and child, siblings and friends. It's just between romantic partners. Second, it must be proven that the abusive spouse intended to abuse the victim, survivor. And third, that the abuse constitutes coercive control, which means that the abusive spouse used power and control to overpower the survivor. Now, coercive control, this is an example of there's probably going to be more definition to that and more real life examples of what that is as claims are coming through the courts, which I would imagine we're likely going to see within the next year and even sooner than that. Now, what's very relevant about these types of claims is that there's no limitation period. So there's no deadline or time frame to advance a claim, such as in medical malpractice, where I mentioned that it's 2 years. So if this occurred many, many years ago, then there is a possibility to advance a claim despite the years passing. And the other thing to point out too is that these claims are not gender specific. Now, while we hear about how women are often abused, we hear more about that. This new type of personal injury claim also applies to men that are abused by women too. So it's not restricted only to women against male partners. And of course, it would apply to same-sex partnerships as well.
Excellent. Thank you so much, Jackie. Such an interesting development in the law, and I think you've explained it really clearly for us. So appreciate that. I do physically demanding construction work. While helping my boss load heavy boxes into a truck, we lost our grip on one of the boxes and it dropped onto my foot. It broke 2 of my toes and I had to take 3 weeks off from work. Do I have a personal injury claim? What kind of compensation could I expect?
All right, so this is a potential WorkSafeBC claim. So I mentioned earlier that these claims are in relation to injuries suffered at work, such as this example, and the claims must be brought through WorkSafeBC and not against someone that was at fault for causing the injury, being a coworker or an employer, manager, contractor. So no matter who's at fault, it doesn't matter who's at fault for the injury. What is relevant is that the injury happened in the course of employment. There are different types of compensation available through WorkSafe, but they're different than other personal injury claims, and that the compensation available through WorkSafe is limited in comparison. So, for example, the types of claims that could be pursued through WorkSafe would include for healthcare benefits, and that would be where WorkSafeBC would cover and pay the cost of medical treatments aimed at recovery. That could be physical therapy costs, medication costs. Another type of claim would be for wage loss benefits. So if you're off work as a result of the workplace injury, then these benefits would be payable based on 90% of your average income. But there's a maximum there to 127,500. So if your income is 127,500 or under, you'll receive 90%. These benefits are often paid every 2 weeks. If your income is over 127,500, then you will be restricted to 90% of that, even if your earnings well exceed that amount. The next type of claim that could potentially be brought is for vocational rehabilitation. And these are services to help workers that are permanently disabled or unable to ever return to their normal, regular job because of the workplace injury. That vocational rehabilitation involves a vocational consultant that works with the injured worker to identify more suitable careers while taking into consideration the worker's skills and interests, as well as something that would be more suitable to the worker's limitations. So for instance, for example, if someone was working in construction and they suffered a career-ending injury, let's say to their dominant arm, where it was not safe for that person to return to that type of work in fear of re-injury, or that person is just entirely incapable of doing the work because of the limitation, then the vocational consultant would look at other less physical or non-physical work options for that worker. They wouldn't be forced to go back to work to a position that they could no longer perform. And the last are permanent disability benefits. So if the injury fits within the definition of permanent disability benefits, would be the injury is not expected to improve. it's expected to be permanent and the limitations are permanent, then there's a possibility to obtain a permanent disability designation where there would be a certain amount calculated according to the law based on the type of injury and the level of disability. And those benefits could be paid either in a lump sum payment or the amount can also be paid monthly. And again, the amount paid will depend on the severity of the injury and the level or percentage of disability that comes from it. What's different about WorkSafeBC claims compared to other claims is that you are not permitted to any compensation for pain and suffering or your full lost wages. So if you are receiving the wage loss benefits and you're receiving 90%, so you would not be able to claim the 10% that you've lost. So they are restricted compared to other claims. So when I say restricted, there's less compensation available.
Excellent. Thank you so much, Jackie. Moving on to our next question. At the mall last week, I slipped on a puddle of water in the food court and injured my back. Since then, I haven't been able to work my usual hours. I also had to hire a babysitter for extra help with my kids. Can I sue for compensation? And if I won, what kind of compensation would I get?
All right. So for most types of claims, not including WorkSafeBC claims, there are different types of compensation, and it's all dependent on circumstances. So the one type of claim that most people are entitled to make with any personal injury claim, not including WorkSafe, would be for what's called non-pecuniary damages, which are known as damages for pain and suffering. This type of compensation takes into account what's happened to you. How serious is the injury? How impactful are those symptoms to your life overall? Do they restrict your ability to do activities you used to enjoy outside of work? What is the extent of the impact on your life as a result? Is it a permanent injury? Is it expected to worsen with time? And how we determine what's reasonable or the amount payable is that there's no chart that we can look at that says this is worth that. What it is we base the amount on what judges have awarded people at trial in similar circumstances, so such as similar injuries, similar ages, similar personal circumstances. And because no two cases are ever identical and judges are different as well, evidence at trial may be presented in different ways, there will always be a range. There'll be a low end of the range, a high end of the range, and a mid. So the amount entitled to may fall within that range depending on circumstances. The next type of claim would be for wage loss. So if you're off work as a result of your injuries, or you can't work as many hours as you did before, then there are two types of wage loss claims that you can bring. The first one is for past wage loss. So that would be wage loss that you've suffered from the date of the accident up until the date of either settlement or trial. So though that wage loss has already happened, it's in the past. Future wage loss is any expected wage loss into the future. So for example, with future wage loss, someone suffers an injury and they used to work part-time and the injury restricts them to working part-time. The injury is considered permanent. It will last a lifetime. The limitation in hours is not expected to change. Then that injured person could make a claim for those lost wages, the difference between what they would earn to retirement. It's a comparison of what they would have earned if this accident never happened and they would continue to work full-time, compared to what they are earning as a result of the injury. And the claim would be for the difference between the two, up until retirement. The next claim is for future care costs. So if your injuries are permanent and the medical experts recommend ongoing treatment and medication for maintenance or to manage ongoing pain to help that person function as well as they can despite their disability, you can make a claim for those anticipated future costs. There's also a potential claim for a loss of housekeeping capacity, where if an injury impacts the injured person's ability to do housework or yard work because of permanent injury, then there's compensation available. And often the compensation is awarded based on what the cost would be to hire someone else to do that work. The expectation is not, well, your spouse can do it, or your kids can do it, or your roommates can do it. They look at what that person has lost in terms of their own capacity and what that cost would be to replace it. Another type, and really the last one that I'll address here, is a claim for what's called special damages. And that's a claim to reimburse the injured person for any out-of-pocket expenses that they've paid for in relation to their injuries. And that could be the cost of attending therapy, medication costs. Perhaps they haven't been able to do their housekeeping. So whatever the cost of housekeeping that they've paid for. And if we look at this scenario in terms of having to hire a babysitter to help with children, then that is a potential cost that can also be reimbursed, as long as a doctor can confirm that that was reasonable and that the injuries prevented this person from being able to provide that child care themselves.
Excellent. Thank you so much, Jackie. And I just want to commend you. I think you have shared with us such rich information in terms of the frameworks that apply to these various types of claims, which has been really helpful, I think, in setting up the different ways in which people may get compensated, the different types of claims. Just noting, we're doing pretty well on time, and the next wave of questions, I think, are a little bit more discreet. So we will have time at the end for live questions. Just wanting to thank you. It's been very helpful to see the different frameworks that apply. So here we've got a question. What's the first thing you should do if you or someone you're with gets injured?
Why don't we use the occupier's liability scenario of slipping and falling on an icy driveway as an example. So the first thing that you should do, whether you're with someone that's injured or you are the person that's injured, is document the details at the scene. So take notes to include whether there were any witnesses to the fall. You should ask them for their names and contact information after you've confirmed with them that they saw what happened. Note the date and time of the fall, where exactly on the driveway the fall happened, how it happened, including how your body responded to it. Did you fall backwards to your side? Did your knee buckle? Did your foot come out because of the ice? You also want to look at the condition of the driveway, exactly where you fell. Record the type of footwear that you were wearing and look to see if there were any warning signs around about potentially slipping. If you have your phone on you, take photographs and a video. Take photographs of the entire driveway plus a close-up of where you fell. And if neighboring properties have all shoveled and iced their driveways, it may not be a bad idea to take photographs there to show that this could have been prevented because others prevented it. And most importantly, always, is seek medical attention as soon as possible. If you feel an ambulance is necessary, call one, don't hesitate. And if you don't feel it's necessary at the time, make an appointment with your family doctor as soon as possible. It's very important when you see the medical professional that you describe when and how the accident happened, along with a description of all of your symptoms so they understand them all, not just the serious ones, but all of the symptoms. And always follow medical advice. That's very important. So if it's recommended you go and get an x-ray or you start therapy, you should be doing that to the best of your ability. And last, report the accident to the homeowner. Tell them that this has happened, when and where.
Excellent. Thank you so much, Jackie. And I gather then those written records are helpful, especially as the process goes on, right? Memories fade, so you've got something, a record from the time. What if you get injured, but you only realize that you're injured a few days later when the pain sets in? What can you do then?
I would recommend you take those steps as soon as you can. So if you've left the property, you may want to go back, see if it still hasn't been iced or salted. Try to determine where it was that you slipped. So document as much as you can and see a medical professional right away. If there's a long delay between you seeing a medical professional and the accident, this may cause a lot of problems with your claims because doctors are hesitant to connect an injury to an accident if a long time has passed, such as, I would say, more than a month. So you should get in there really as soon as you can.
Excellent. Thank you, Jackie. Um, this next question. I want to make a personal injury claim, but I don't know where to take my claim. Is it small claims, Supreme Court, the Civil Resolution Tribunal, or another tribunal? And how long will it take?
Sure, I'll address this as simply as I can in terms of the potential value of the compensation, because that's really one of the most important factors when you're choosing what type of court you're going to pursue your claim in. So the BC Civil Resolution Tribunal, they handle disputes for claims for $5,000 or less. And this is an online tribunal, which means that the claim is conducted almost entirely in writing only. The next level of court is the BC Small Claims Court, which is through the Provincial Court of British Columbia. And this court handles disputes for amounts ranging from $5,001 to $35,000. What's important to note is if the claim turns out to be worth more than $35, then no matter how much that value is, if you stay in the small claims court, you're restricted to 35,000. So even if, let's say, the claim is worth six figures, the maximum would be 35,000. And the next level of court to start a claim would be the BC Supreme Court. And this court handles claims for amounts over 35,000. And there's no limit on the maximum amount that can be awarded.
Excellent. Thank you, Jackie. So really, I should have had it sequenced with Civil Resolution Tribunal at the top in terms of the level of compensation that would be potentially available to the claimant. And just going back to that last question, how long it will take.
Oh, this is the magic question. I would say most often the length of time really depends on recovery. And if someone is left with an injury that is not fully resolving and it's continuing, and often people will improve and then they'll hit a plateau. Sometimes the injuries get worse depending on the type of injury. And really, you want to wait to see how that injury progresses. If the injury is ongoing, the claim is going to be longer because typically the extent of the injury will not be known for several years in, and only after that person has tried a variety of different things to get better. So if you resolve your claim without knowing this really important information, that could really limit you and not protect you for the future if things do go seriously wrong. Once you resolve the case, either through settlement or trial, it's over. Absolutely over.
Thank you, Jackie. And you set us up for our next question, which is if your injuries get worse, right? Your claim is ongoing. You've filed within, I imagine, the limitation period. Can I make a claim for increased compensation?
Yes, so certainly if injuries worsen or if they improve, then that is going to really dictate your claim. So again, a personal injury claim is highly connected to the type of injury and the length of time that it continues for, and really getting to that point in time where you've tried everything and doctors are comfortable in saying, I don't think this is going to resolve, that this is something you need to live with. And then you can look at your picture moving forward to really determine what is fair compensation. And it's really about what's fair and reasonable according to what the law says. It's not someone's personal opinion. I can say that I've never had a client that's been happy at the end of a claim because nothing will replace what's happened to you. But the only way that we can do that is through compensation to hopefully make that person's life a little bit easier and a little bit better moving forward.
Thank you so much, Jackie. Um, when is the best time to reach out and contact a lawyer? And for a personal injury claim, do you need to have a lawyer, or is it something that you could do on your own?
It's always a personal choice. Always, always, always a personal choice. Whether you want to hire a lawyer or proceed on your own, there's nothing requiring you to hire a lawyer. The problem is that the law is very complicated and complex, and there are certain steps that must be taken within certain time periods that would be generally unknown to the public without legal training. This can have devastating consequences where the claim may be dismissed because of lack of evidence, because that person didn't know to preserve or even provide certain pieces of evidence. But really, a lot of these personal injury claims deal with insurance. Most of them do. And insurance companies are billion-dollar corporations. If you don't have a lawyer, that playing field is likely to be extremely unlevel and unfair because that insurance company has unlimited funds to defend the claim. And if you're on your own, it's very difficult to go up against that yourself. I always advise that people just contact a lawyer. Personal injury lawyers, most of us offer free consultations. And I always think it's worthwhile to at least find out what your options are and whether you have a claim. Like, what's the likelihood of success? And again, often there's no cost to that. Um, Personal injury lawyers as well. I mean, you need to know that if you hire a lawyer, it's going to cost money. Most lawyers charge by the hour, and clients receive bills on a monthly basis. In personal injury, most lawyers offer what's called a contingency fee agreement, which is where the lawyer is not paid by the hour, but it's based on a percentage of the settlement or trial judgment. And really, that helps people because you're injured and not working. Finances can be extremely strained, and people would be disadvantaged and prejudiced against really in not being able to hire a lawyer because they can't pay upfront. And this is not the type of system that you should be punished for not having the funds. It should be available to everyone. And this is one small aspect that makes it more available to everyone.
Excellent. Thank you so much, Jackie. And we've got a couple of questions before we turn to our
Sure.
questions from our guest today. So let's say you do have an appointment with your lawyer and you're trying to figure out like how to prepare for your meeting. What are the best things you can do to prepare? What types of questions should you ask? And how do you know which lawyer to choose?
Why don't I start off with choosing one first? So I recommend you read reviews. You can tell which ones are real. And I think it's important to have some insight about others' experiences with that lawyer. I'd recommend reading the lawyer's profile to look at their background and their experience level and ask around. If your friends or family have any recommendations, firsthand experience is often very, very telling. So they may have a good recommendation. If you meet with the lawyer, first of all, find out if it's free or not so that you're prepared. Bring all the details you possibly can about how the accident happened, the date, the location, photographs and videos, medical documents, just everything you have, bring it. And the lawyer may want to look at that. When you're meeting with the lawyer, I would highly recommend that you ask about the lawyer's experience level. How long have they been practicing? What prior experience do they have in handling these types of claims? Do they have court experience? Ask about the legal fees. What are they? What can be expected? And who pays for the legal expenses along the way? And those are called disbursements. So that's important. Most lawyers will cover that, and the insurance company will pay for that at the end of the claim. But sometimes that is not what happens. So you should know what you're getting into first. And I always recommend find out if the lawyer charges interest on those disbursements. The interest can be extremely high, and it's unknown what it is at the beginning. A lot do not charge interest. So I think it's important to know what you're getting into and ask the lawyer what to expect moving forward. What type of communication or contact should you expect, or tell them what you want. They're working for you. It's very important that you hire a lawyer that you're comfortable with. So interview as many lawyers as you want. Find someone that you are comfortable with and confident in. This could be a very long relationship. There's an enormous amount of trust. That lawyer could be privy to personal details about your life. Do your best to be with someone that you're confident in and you trust. Don't just go with someone because they're there. It'll make it a very difficult process on top of what you're dealing with in terms of the injury.
Excellent. Thank you so much, Jackie. And this is our last question before we turn to questions from our guests today. I'm a homeowner. What precautions should you take to prevent injuries and protect yourself against potential claims?
Insurance, insurance, insurance. Make sure you have insurance. Make sure that you ask your broker if that insurance covers situations such as injuries on your property. You want to regularly maintain your property, make sure there aren't any hazards. If your stairs are slippery, put some non-stick there, replace them, maintain them, and keep an eye out. If you're expecting people, take a look to see if it's safe.
Excellent. Thank you. So turning to live questions, and I see we've got a number of questions that our team has responded to in writing, so that's excellent. The first one I'll turn to here is about waivers. Regarding waivers, what if a waiver is not specifically signed, but just posted on a sign or on the back of your ski pass?
Unfortunately, it's part of oftentimes it's often a term of purchasing the ticket. Those ski hills, they cover themselves quite well. So unfortunately, it's more likely than not that it'll be enforceable to an adult, not a child.
Thank you, Jackie. Here's another one. As a homeowner, I am required, sorry, I am required, am I required to clear snow on the sidewalk that is not on my property, but on the City of Vancouver property? Am I liable if a passerby falls down on the sidewalk and has an injury?
This is something that I know a little bit about, but not a lot. But my understanding is that you are liable in the city of Vancouver to shovel your sidewalk, that the city offloads that responsibility unless that's changed. Um, that's my understanding.
Thank you. A question here about the waiver and the infant. If a parent signs a waiver for an infant, is the waiver not valid?
It's not that it's not valid, it would not be enforceable. So a parent cannot waive the right of an infant, which is anyone under the age of 19. So it would not be enforceable if that child was injured. So, and that's very specific to British Columbia and a few other provinces. So we're lucky here that children are protected against.
And I imagine in that case, the person bringing the claim, the infant being represented by an adult in the legal proceeding, would still need to prove that there was fault on the part, let's say it's an occupier's liability, that there was negligence and so forth, as you described before.
Absolutely. So what the waiver will do will either disentitle you to make a claim no matter what happens during the activity, and it's very wide ranging. Okay. Or if the waiver is not enforceable, such as with a child, then you would still have to prove all of the elements in order to have the claim, but it would not be enforceable. So it's a complete defense, but it's not with respect to infants. So you can continue pursuing that claim, but the same rules of proving the claim and the evidence required is the same.
Thank you so much for that, Jackie. And we'll see how much time we have for more questions. Question here about WorkSafeBC offers registration as a homeowner hiring casual labor or workers that are not otherwise registered with WCBBC. The cost is minimal. Do you recommend that a homeowner registers with WorkSafeBC if they hire casual workers?
Highly recommend. Highly recommend. You want to protect yourself because oftentimes it's that one time, and that can have devastating consequences if you don't have any insurance. It's not a chance you want to take because you would be personally responsible if the claim was successful. You could lose your house. You could have your wages garnished, which means a percentage of your wages would be paid to the claimant. It's not something you want to play with at all.
Thank you so much, Jackie. I just wanted to thank everybody for these questions. These are excellent questions. We have time for one more before we wrap up today's broadcast. Thank you to the team at People's Law School. I see that most of these questions, actually all the questions, have written responses, so that's excellent. Jackie, if I organize moderate risk group outdoor activities informally, so there's no waiver and it's unpaid, such as running, hiking, or park calisthenics, could I be liable for an injury to a participant?
That's a really difficult question to answer because it's going to depend on a number of different circumstances. If you are wholly responsible over the activity in terms of providing the venue and other items, and injuries come out of that or caused because of that, then that could be trouble.
Thank you so
I
much, Jack.
always recommend insurance. Get it, get it, get it. It's worth it if something happens.
Amazing. Thank you so much. And anything that maybe came to mind while we were discussing today that you'd like to share with our guests before we wrap up for the day?
I think what's most important is always knowing what your rights are. So reach out to lawyers and have a consultation if you have questions. There's no pressure, there's no obligation at all. And I always emphasize to people, make sure you choose someone that you are comfortable with and you're confident in. It will make the process smooth, and let that lawyer know about things that you need and the support that you need. If you don't know what it is, it's hard to provide that service, and everyone is different. So make your wants known and choose someone that you feel good about.
Amazing. Thank you so much, Jackie. And a big thank you to all our guests who joined us here today. You are here learning about your rights and learning about the law. And so I think what you've suggested, Jackie, makes perfect sense. Like, we really want to make sure that if you are injured or someone close to you is injured, that they understand their legal rights. And the best way to do that is to speak to somebody who's got expertise in the area, being a lawyer. So thank you so much for that. And thank you, everyone, for joining us here today. And we look forward to seeing you all again in the fall. Take care. Bye for
Take
now.
care. My pleasure. Thank you.
Thank you, Jackie.